But we hope you are all doing well, getting ready for the holiday season. Certainly wish everyone on the call very happy holidays and happy New Year as we get entered here into 2025. Just want to thank Maggie Premo for being on the line today. We're having a discussion around estate planning and different basics and things that should be considered as it comes to that important aspect of our financial planning lives. Maggie is the chair of Neider and is it Boucher? Is that how you pronounce it?
Neider and Boucher.
Neider and Boucher. Trust and Estates team, and she focuses her practice on estate planning, probate, and trust administration. She graduated from UW Law School here in our backyard, and just fortunate to have her time here. And as Kevin usually knows, I try and start out with a little bit of joke in regards to the topic that we're talking about. So Kevin, I'm going to ask you a question.
Yep.
Do you know the only things that are certain in life?
Well, no, what's that?
Death, taxes, and people procrastinating with their estate plan.
Pretty good. Pretty good.
And then that last one I'll say, because I hear all of you laughing, all of the attendees. Death and taxes may be inevitable, but at least death doesn't get worse every year. So you can deal with Kevin and I as far as the taxes getting worse every year, but Maggie is a wealth of knowledge when it comes to estate planning. And we're going to turn it over to her for her presentation. We'll just go for roughly a 45-minute period of time. And then if you can hold questions until the end, you can raise your hand and we can unmute your line. We're being in this Zoom atmosphere. You can move the picture around if you can't see the slides. So without further ado, I am going to turn it over to Maggie. So thanks, Maggie.
Yeah, thank you, John. Thanks, Kevin. I usually start out with a joke too, so that's good.
Oh, very good.
Funny. So I'll try not to bore you all to death today, at least until you get your estate plan done. So that's my joke.
I like yours better.
You'd say that, Kevin.
All right, let me try to share my screen here. Share. Okay, did that work?
We're good.
Yep.
Okay.
Looks great.
All right, great. Okay. Okay. So thanks for having me today. As John mentioned, I work at Neider and Boucher. We're located on the west side of Madison, actually not too far from John and Kevin's office. I've been doing estate planning since 2009, and I've been doing solely estate planning since 2015. When I started my practice, I started off doing all sorts of different areas of the law, but I discovered that estate planning was really my passion. Even though talking about death and dying every day, it's still somewhat of a happy area of the law because you're really helping people accomplish something that maybe they've procrastinated about for a long time, and giving people some peace of mind that things will go well for them and their family after they're gone. I always have to give this, I'm sorry, a disclaimer because I'm a lawyer. I just have to let everyone know this is not legal advice. Everybody's situation is different. So the information today is intended to be general in nature and educational in nature. So please don't rely on this as legal advice specific to your own situation. Okay, so we'll start off with kind of the basic one that I think most people have heard of. What is a will? This is my dog, Tulio, looking inquisitive. I try to personalize the presentation because this is such a personal area of law, such a kind of a human element to it. So I try to humanize it. So most people have heard of a will, either have one or have thought about having one. What a will is a legal document that says what happens when you pass away with your assets. And it appoints a person or a company to be in charge of the distribution of your assets to your beneficiaries in accordance with the terms of your will. So there's just some highlights about wills. So there are formal requirements that are set out in our Wisconsin statutes that have to be met in order for a will to be legally valid. As I mentioned, the will directs what happens to your assets that are a part of your estate at death. And I wanted to mention earlier in a slide too, the term estate planning, I know can sound somewhat intimidating, the word estate, especially that it maybe suggests that people have to be really wealthy to engage in it. And sometimes clients will say to me, well, I don't have an estate, I don't need estate planning. But really it's intended to be just a general term to describe planning that you do to provide for what happens if you become disabled or upon your death. So it doesn't require anyone to have a certain amount of wealth to engage in this sort of planning. So going back to a will, in a will, you would appoint who would be your personal representative. So that's the term that's used in Wisconsin, but in other states, they'll refer to it as an executor, but it means the same thing. It's the person who is in charge of gathering your assets at your passing and then distributing them out to your beneficiaries according to what your will says. In Wisconsin, you can attach to your will or keep with your will a list of tangible personal property. So your stuff, your collectibles, tools, artwork, jewelry. You can attach a list and say, here's who gets this item, sign it and date it. And it doesn't have to meet those same formalities that it would to execute a change to your will. So it doesn't need to have the two witnesses. You can do that more informally in Wisconsin with that use of that tangible personal property list. So that comes in really helpful for anything that may be contested. So I have a sister and we both I'm sure covet certain items of jewelry that maybe would be passed down to us from family members. So they could use that to say, you know, this ring goes to this daughter, this necklace goes to this daughter, just a way to prevent any sort of fighting when you pass away, if you know that there's items in particular that might be desired by more than one person. And then very importantly, I have a picture of my two kids here. What you do in a will, if you have minor children or you have children with disabilities who may be under guardianship, as you nominate guardians for your children if you should die. And so this, talking about money, you know, that's obviously an important thing too, but really this is so key if you have minors to set out a plan of a nomination for who would take care of your kids if something happens to you, because there's just nothing worse than fighting over that when somebody passes away, or trying to guess what somebody wanted if they didn't have it written down in their will. So here is a common one that I hear almost every day is, well, I have a will, so my estate will avoid probate. So true or false? Think about that. The answer is false. So the will, the process of having your will honored is called the probate process. So I have a picture here of my friend Jeff Okazaki. He's the Dane County Register and Probate, so he oversees all the probates in our county. And the probate it's a court process. It can be informal or formal, depending on if there is any disagreement and certain other distinctions. But most of the probates we see are informal probates. So the court is still involved, but it doesn't necessarily involve going before a judge or a court commissioner. It's mostly done via submissions to the court electronically, and then having the court review things, not as a part of a hearing. So what is probate? I put a picture of some scary, expensive, fancy looking lawyers here because I think that's commonly who ends up with a lot of the money when you have a probate proceeding. So probate, the reason that lawyers are often involved is that oftentimes people are intimidated by having to go through court. So even in an informal probate, the process of submitting these papers to the court, doing it electronically or in person, it can be very intimidating. And so people will oftentimes hire counsel to help them with the process. So probate has a bad name. It's in Wisconsin. It tends to be, I think, somewhat easier than it can be in other states. But in general, probates take quite a while. So from the time someone dies until the time their estate is administered, tends to be at least a year in most cases. And every probate is different, but I would just say that's an average that we see at our office. It tends to be expensive, so there is a fee that's paid to the court that's based on the size of the estate that's going through probate. So that's a fee that comes out of someone's estate. And then, as I mentioned, oftentimes legal counsel is involved, which adds to the expense as well. It oftentimes will lead to disputes. I shouldn't say oftentimes, but it can lead to disputes. So because it's an open court proceeding, it is somewhat easy for someone who is disgruntled with what is going on in the probate to insert themselves into that legal action because it's already open. There's already a court case open. They can kind of more easily slip in to contest something. It's also a public process. So there's something that gets published in the newspaper saying that there's a probate. It goes on, if you go on CCAP, the online circuit court records, you can see if there's a probate and you can kind of do the sleuthing to figure out how much money is going through the probate. And if someone is very, very nosy, they can actually go to the courthouse and request the records and see the will and see all of the assets that are a part of the probate too. So it has those elements to it. One thing about probate that I think is interesting that not everybody knows is that there's some mandatory requirement rules when a probate is opened. So if I have a will and I leave everything to the Humane Society in my will, you would think that, oh, well, just the Humane Society will receive notice because they're the sole beneficiary. But the way it works is that not only do they receive notice, but anybody who would have received my estate if I didn't have a will also gets to receive notice of the probate. So if I have disinherited my children and it goes through probate, they still receive notice. They can receive a copy of the will and they can receive notice of the probate, which again lends its way to disputes because once somebody realizes that there's an estate and they've been left out, it's real easy for them to then sneak in and try to contest it. So then we'll contrast that process, the will, with joint or individual revocable trusts. So this is an alternative to having a will direct the distribution of your assets at your death. You can have a trust instead. And so this is something that I think also a lot of people have heard of, but maybe have a hard time understanding because it's just a little bit different than a will and what most people have heard of. So what is a trust? In essence, a trust is a relationship between kind of these three people, these three roles. They don't always have to be people in these roles. They can be charities or companies. But I put together this graph kind of how I have my plan set out to sort of illustrate how it can look. So you have the settlers of the trust, so the people that created the trust. So my husband and I are the settlers of the trust. The trustees of the trust are the people who are in charge of carrying out the terms of the trust, managing the trust assets, making distributions from the trust in accordance with the terms, and then the beneficiaries of the trust. So whoever the trust is set up to benefit. So it's kind of those three roles, that relationship between those three roles is what makes a trust. Practically speaking, it is a written document that looks somewhat like a will in that it says, here's who's in charge. They're called trustees instead of personal representatives. And then it talks about what are the different rules for trust assets. So it spells out what happens to those trust assets during someone's life and at death. And then the layers down, I just intended to show how these roles can change over time. So my husband and I will always be the settlers of the trust. We created it, but we might not always be the trustees of the trust. If we are deceased or incapacitated, then it goes down to my sister, who would take over then the administration of the trust. If she can't act, then it goes down to my parents. And then the beneficiaries. So it starts off with my husband and I and our kids and our dogs are the beneficiaries. But then when my husband and I die, it's my two kids who are the beneficiaries. But if we all die together, these are horrible things to talk about, but if we all die together, then it goes down to my nephew, who's the baby I'm holding in that picture. And then if he's gone too, then I've got a bunch of animal charities in there because I'm an animal lover. So that can just kind of show how over time, the different roles can change in a trust. So funding the trust. So this is how the trust works and how it works to avoid probate. So after setting up the trust, you want to coordinate your various assets with that trust. And you can do that in a few different ways. You can retitle your assets. So you can take a house and title it in the name of your trust, and then technically the trust becomes the owner. Or you can name the trust as the beneficiary on assets. So you can set up, even on your real estate, a beneficiary that says, when I'm deceased, this who is automatically without probate becomes the owner of the house, and you can set that up to be the trust. So either of those methods work to get your assets into the trust and avoid having to go through a probate. And you'll notice I don't have retirement assets on here as going into the trust. Sometimes that's a good idea, sometimes it's not, but things like bank accounts, you can set up beneficiaries to be the trust, life insurance, investments, so forth. Here's some just common misconceptions or common questions I get when people are thinking about setting up trusts. Oftentimes they'll say, well, I don't want to have to update my trust every time I get a new asset. You know, if I sell this house and buy a new one, I don't have to come back into you and redo my trust. And so the response to that is that you don't have to update your trust document anytime you buy or sell assets, exchange assets. You just always want to remember that you have this trust so that when you do buy the new asset, you remember to coordinate it with your estate plan. So naming the trust as beneficiary perhaps, or retitling the asset, but you don't have to change the underlying document terms of your trust necessarily. Oftentimes, people will ask if this will protect against nursing homes. The type of trust I'm talking about here, this revocable trust, meaning it can be changed throughout your lifetime, that does not offer any sort of nursing home protection. That's a different type of trust. And then I'd say another common misconception is that trusts are just for the super wealthy. We have clients of all walks of life who benefit from having a trust for some of those reasons that we talked about before with probates, that due to the public element or family dynamics, you know, maybe the privacy of the trust is the best fit. So there can be reasons for people to do it that are beyond money reasons, monetary reasons. So beneficiary designation, that's another part of the estate planning. This is a real familiar form to us because we use it a lot for clients. This is people who are a part of the employee trust funds, have employee trust funds account through the state or the UW. This is a beneficiary designation form where you can designate beneficiaries to receive assets upon death. There is a method for completing these two, and so I will oftentimes caution people to just think about how your estate plan works as a whole, because sometimes you can have some unintended consequences by filling this out a certain way and not thinking about how it plays into maybe how the rest of your estate plan is set up. The term purse stirpes, that comes into play when you're talking about those beneficiary designation forms. So if I name my sister as a beneficiary per stirpes, what that means is that if my sister passes away before me, her share of that account would go down to her children, her lineal descendants. And so that's a way that you can set up beneficiary designations if that's how you want it set up. If you want to make sure that if a beneficiary passes, their share stays in their family line, you can use those per stirpes words. POD and TOD, those are common terms that are used when talking about estate planning too. So POD stands for payable on death, and TOD stands for transfer on death. They're kind of different ways of saying the same thing. It's just different types of assets use the different lingo. one caution I like to give about using POD, TOD designations on things and relying perhaps solely on those. So a situation that we've come across quite often would be someone who has, let's say they have 5 kids, and they name their 5 kids as the transfer on death beneficiaries of their real estate. So mom or dad passes, all of a sudden these 5 kids are owning this real estate together. And there's no rules set out about the co-ownership. So it can get messy when the property needs to be sold, and who's choosing the realtor? How are we determining the sale price? Who's paying the expenses on the house before it sells? Is one sibling paying and the rest, and then having to get reimbursed from the rest? What if somebody's not reimbursing? What if one of the siblings was living there with mom or dad in their golden years and helping them, and now all of a sudden mom and dad are gone and their siblings are trying to kick them out of the house to sell it? And what if they don't agree, but they're a 1/5 owner? So it can just get really, really messy. So even though it seems super simple to just name payable on death or transfer on death beneficiaries on everything, it can create these unintended consequences. And then speaking of unintended consequences, this is another common thing that happens, is that we'll find clients will be encouraged perhaps by the teller at the bank as they're setting up an account to name a child as a joint owner on the account. We run into those situations, unintended consequences, again, with this sort of setup as well. So if parent dies and then that account automatically passes to the joint owner, the other child, that child has no obligation to share that account with siblings. That child could get sued or be going through a divorce. There could be something going on where that account that the parent intended to go to all their children then gets swept up as a part of that legal proceeding. Or if something happens, if that child dies shortly thereafter, then that account ends up going to that child's beneficiaries and not necessarily the original owner's other children. So there can be all sorts of issues that we see with that joint account ownership too. It's just not always, it just doesn't always work out quite as simply as one would hope it would. Other pointers to keep in mind when you're thinking about beneficiary designations, such as beneficiary designations on retirement accounts or life insurance, or setting up payable on death or joint accounts, those sorts of designations will govern over your will or your trust. So if you have those beneficiary designations set up, those assets are not passing according to what you have in your will or you have in your trust. They're passing according to whatever you have set up in that POD or TOD or beneficiary designation. Again, we see some of those unintended consequences. So what if one of those beneficiaries dies, leaving behind minor children, and then the minor children are to take their share? It can result in a really young grandchild getting a large sum at age 18. There's not the same kind of safeguards that you can have set up in a will or a trust to say, well, until that grandchild is 25, that money stays held back for them to be used for their education or their health. So you can't kind of have that same customization that you can have with those assets that you could with a will or a trust. The other problem that we see when people set up their accounts to just be all payable by beneficiary, if they have multiple children or multiple beneficiaries, then there really there isn't created any sort of a common fund from which to pay expenses. So there's always going to be expenses after someone dies, whether it's, a funeral or just final bills, just things that need to get paid to clean up before the rest of the assets can be distributed. So if everything kind of goes out separately via beneficiary designation, it'll sometimes fall on one child to pay everything and then have to seek reimbursement from the other. And that can cause some family strife. Sometimes if people aren't cooperating. And then there's this, my least favorite approach, which is the do nothing, I won't care, I'm dead approach, which I've also heard people suggest or want. This is the one I would urge you not to adopt. It's good to have some control and to have some care into what you're doing with your planning. but I have to present it because it is an option. Blended family and probate, a default rule. So this is another reason why the do nothing, I won't care, I'm dead approach isn't great. So this is, I'm trying to remember why I put this. Oh, this is my sister and I with our Barbies who were a blended family, all sorts of remarriages, kids from second marriages. These are Barbies who would have needed an estate plan because what can happen is if you remarry and you have children from a prior marriage, or you and your spouse have children from a prior marriage, that's where the default rules in the law may not reflect what you want to have happen with your assets based on marital property laws that we have in the state of Wisconsin and based on some probate default rules. So the probate default rules will say that even if you're married, your kids from your prior marriage will receive half of the assets, your interest in marital property assets. There may be assets that you don't consider to be marital property, but the law does. And so this has been, this is an extremely stressful situation if this happens for surviving spouse and children of the deceased spouse, because there can be a lot of fighting over who gets what and what was intended and what was wanted. So when you rely on those default rules, they don't always say what you think they're going to say, or maybe what you want them to say. So you can be really setting up your family for some fights and some hard times. The other situation where the default rules don't always say what people want them to is maybe someone who's in a long-term relationship with someone but isn't legally married. And there's really no legal mechanism that would allow then for that long-term partner to receive anything when someone dies. So we've seen that happen where the person dies and some long-lost relatives receive all of their assets, whereas really probably what their intention would have been would to have their longtime partner receive them, but because they weren't married, that didn't happen. So wouldn't you rather have a say? So this is another plug for doing an estate plan. Even if you don't have people that you care about in your life, there may be charities that you care about. I put the Goodman Community Center here, but there's all sorts of, any sort of charity you want, you could put in there just to say, okay, I don't have family that I'm close to, but I want to make sure these certain charities are supported. You can also insert a charity into your estate planning documents as kind of a backup to a backup. So we'll oftentimes put in provisions in the trust or the wills that we prepare that say, if everyone in our family line is gone, here's who receives the assets. And sometimes that is a charity. If there's you don't want your distant cousins receiving the assets. We do see every once in a while, we see probates where people pass and they don't have a will and they don't have any close family, and you're calling a cousin across the country who's just about to receive some very, very good news about being the beneficiary of an estate. So it does happen. It does happen. And some advanced planning topics. So these are things to think about, but that are beyond the scope of the presentation today. So pet planning, I like to do that. I mentioned I'm an animal lover, so you can put in provisions for caretakers for animals and maybe funds to care for your animals after you're gone. If you have individuals in your life who have disabilities, there's something called special needs planning that's very important to do. There's lots of rules about retirement benefits and beneficiaries, what you can do with your retirement accounts that can require some more advanced planning. If you own a business, thinking about the succession of that business, especially if it's a family business that you want to pass on. Tax planning surrounding estate planning, spendthrift planning. So if you have a loved one who struggles with money, going through a bankruptcy, planning that you can do to protect those assets in a way that still benefits them, but that the money wouldn't just be blown away on creditors. Marital property, that's the laws we have here in Wisconsin governing the property of married people that can play into the planning. And then planning if you have minor children as well, and maybe setting up something for them to protect them if you pass while they're young. Other really important estate planning documents to have that maybe don't get all the attention that they deserve, but in my opinion are just very important too. Power of attorney for healthcare. This is a picture of me in the hospital a couple of years ago, and I did have my power of attorney. So This is something you set up to appoint someone to make decisions for you, healthcare decisions for you during your life, if you are unable to make them yourself. So what this does is it avoids having to go through a guardianship proceeding. So if you don't have a healthcare power of attorney set up, and there's nobody with the legal authority to make those decisions for you, and you can't make them yourself, the decision would likely go before a judge as a part of a guardianship proceeding. And that is fun for no one. That is a very stressful experience, embarrassing, expensive. So this is a really straightforward document that you can do to prevent that from happening. Important points here are to trust that who you appoint will honor your wishes. So appoint someone that you feel comfortable talking to about your healthcare wishes. These are some sensitive topics. What are your philosophies about end of life care, thresholds for pain, all sorts of really kind of touchy subjects. So make sure you appoint someone that you're okay talking with about these subjects, and that you know will honor what you want, that won't maybe insert their own wishes into the decision, but will honor what you want for your own healthcare. And financial power of attorney. This is my Aunt Pat, who would make an excellent financial power of attorney because she is very organized and keeps very good records. So you don't always want to have the same people necessarily as your healthcare power of attorney, agent under your healthcare power of attorney, as you do for finances and property, because they're dealing with two different topics. So this is during your lifetime. If you need assistance paying your bills, dealing with Social Security Administration, filing your tax returns. These are things that a financial power of attorney can help you with. And you can have one that is immediate or springing. So immediate means you're immediately giving that power to that person, not necessarily taking away your own power to manage your own finances, but that you're trusting someone else to have that power at the same time. Or you can have a springing financial power of attorney. So that only springs into action if you have been determined to not be able to manage your own finances. And so this is a good person to talk to as well. You want to make sure that this is someone who knows about all the different people on your team. They know who your financial planners, financial advisors are. They know who your CPA, your attorney, insurance agents. You want them to know kind of everybody on your team, so that if they need to step in and start helping you, they know who to contact to help. Then we have an authorization for final disposition instructions. So this document is designed to prevent a situation in which there's a disagreement about what happens to your body after you've passed away, and there's no one with the legal authority to make the decision. So I had heard at one point, I don't know if this is true, but I had heard at one point that this document came to be because there was a woman who passed away who was survived by 2 children. They had equal authority under the law to decide what happened to mom's body. They couldn't decide, so it went to court and it got held up for a long time. So now we have this document that you can execute in Wisconsin that assigns an order of agents. So just like with healthcare, here's my first agent, here's my second, you would assign a representative and a backup representative. You can still say what your wishes are in this document. You can specify if you have something set up already with a funeral home, or for example, you want a green burial. I put the Farley Center on there because that's a popular one. You can put all of those wishes in that document. So it also serves to give some peace of mind to whoever you've appointed in that position, that they can look at that document and feel secure that they're doing what you had wanted. But it really gives the person who has the decision-making authority, the ultimate authority to act then, instead of having things held up because there's maybe a disagreement. People, when loved ones die, there tends to be disagreements that kind of bubble over. And so even if you're thinking, oh, this would never happen in my family, everybody gets along, sometimes when somebody passes away, the dynamic can shift and change. And so the more you have put in place, the better. Even though these aren't fun ones to talk about or to execute, they can be really important. Okay, this is just my plug for our law firm. These are our wonderful paralegals. If you'd like to contact me, my email and phone number there. And then just a little bit about the process. So I think it's really important when people go through this process that they feel safe, they feel comfortable. We're talking about some really, really personal things here. So how the process works at my firm is we set up an initial meeting to talk about what your wishes are, what your situation is. We give a little bit of homework before you come in with some questions to think about before you come in and some basic information. We talk about, excuse me, your goals, things that are concerning to you and how they might be addressed. And then go over what the timeline would be to complete and the cost, which varies, depending on the complexity of the situation. We draft the documents. You would look at them, ask any questions that you have, and then ultimately, when you were ready to sign, to come in and then sign in front of witnesses and a notary, just to make sure everything's executed appropriately in accordance with the law. People sometimes ask, how often do I need to update my estate plan? And there's no real perfect answer to this. It really is different for everyone. I'd say if there's a big change in your life, like a big change in your family or in your finances, that's sometimes a good reason to prompt you to come in and look at your estate plan, or even just pull out your estate planning documents to read through them and make sure they still make sense to you and say what you want them to say. Otherwise, every 3 to 5 years, we say is just a good time to review. Not necessarily that you have to change them, but just that you look through, because a lot can change in 3 to 5 years, a lot more than you think. And so that's kind of a good timeline to pull those out and look at those. Oh, the other thing I always like to mention about most of the documents that you sign as part of the estate planning process are revocable and changeable and amendable. So you can change your mind and change them later unless you're signing an irrevocable trust. I think oftentimes the reluctance to do an estate plan is that, oh, it's set in stone and I've done it and I can't change it, but that's really not the case. It can be changed at any time as long as you are of sound mind. Okay, so I was a little bit faster, I think, than you wanted. I'm sorry, I must have talked a little too fast, but I can open it up for questions now, if there are any.
Appreciate that, Maggie.
Sure.
Yeah, if you want to just raise your hand, we can unmute your line. So we'll look to that if anyone does have any questions. And maybe while people are maybe considering if they want to ask any questions, I guess I would mention in regards to financial power of attorney, often one good thing to remember too is just because you have it in place doesn't mean that it's structured accordingly to your investment accounts, because a lot of times these custodians of the investment accounts themselves will require you to share the financial power of attorney with them, and they have a form for that too. So we can help on that side of things when it comes to the financial care power of attorney, but it's just good to have that in place well before something is needed. Because it just makes things easier on the entire process. The other thing too that Maggie maybe you want to touch on would be, can you give any instances on why somebody might want irrevocable, and or maybe for someone that's thinking, how do I protect my assets if I go into long-term care? Some of your thoughts when it comes to that.
Yeah, that would be one instance where maybe an irrevocable trust would make sense if you wanted to shield assets, take them out of your name so they no longer belong to you. You can put them into an irrevocable trust, and then the assets belong to the irrevocable trust and they aren't in your name. So that could perhaps qualify you to receive certain benefits then from the government that can help pay for your care instead. That's a really kind of complex area of the law. So we have an attorney at our firm who focuses her practice on that, because there's a lot of moving pieces there that you want to consider before you tie up your assets into an irrevocable trust. There can be tax reasons to do it, to gift assets into an irrevocable trust. That would be another reason. Or you just want to give assets away maybe to a family member, but you don't want them to have access to it. So you gift it to an irrevocable trust, and that can be used for their benefit, but doesn't legally belong then to that beneficiary.
Yeah, no, this has been great. The only question I had was, a lot of the folks on our clientele are retirees, but certainly many of them have kids and, grandkids. At what point would you suggest that, age-wise, that folks start coming in to see an estate planning attorney like yourself? Is there a certain triggering event, or is it, what are your thoughts on that front?
Yeah, we have some people, as soon as their children turn 18, they bring them on and they get their healthcare power of attorney and their financial power of attorney done. That's pretty rare for people to be that proactive. But technically, when you're 18, you're an adult, and if you're in the hospital, your parents can't make those decisions for you anymore. So it's a good idea to have those put in place even at that young of an age. I would say most of the time we'll see people come in when they're expecting their first child because they really want to get those guardianship proceedings or guardianship provisions put in place before that happens. Although any time is a good time. So even if it's after you have your child, it's a good time to do it. But I would say that tends to be sort of a common triggering event, is the birth of a child or an inheritance of a large amount of money. That can be too, where all of a sudden they went from having no estate to having an estate, and they want to have some control over what happens to it.
Okay, yeah, appreciate that. It's helpful.
Yeah.
Well, and I'm not seeing any questions right now. We just want to say thanks, Maggie, for giving us your time here and your expertise. If you want to share your contact information maybe one more time, I don't know if you can flip
sure.
that slide. So if anyone is interested in getting in touch with Maggie, there's the information. You could certainly reach out to us and we can provide this as well. But appreciate everyone's time today. And yeah, with that, guys have a great week and a very Merry Christmas.
Thank you.
Yeah, take care, everyone.
Thanks, everybody.
Yep, thank
Bye.
you.